Welcome to the next instalment of the Anson's podcast. If you're watching this video, you might be wondering about what an individual bankruptcy might look like, what that could involve, and what you might expect to find within it. So within this, we're going to dive into that. We're going to have a discussion around all of those things and what you might find in the bankruptcy proceedings and other alternatives that might be available to you. We're going to start with the individual. So you and I, the natural person, the individual, and there's two main areas. We've got bankruptcy and we've got IVAs or individual voluntary arrangements. Do you want to explain a bit about what a bankruptcy is so that anybody watching this can understand what we're talking about?
I mean, the starting point for both corporate and individuals insolvency, in effect, the definitions for both is really that you cannot pay your debts as they fall due, or cash flow, a substantial cash flow issue, or that your liabilities are significantly more than your assets to the point that you're unable to sort of keep funding your liabilities, and therefore a process will be initiated either by you or by somebody else to put you into a formal insolvency process. Now, the formal process for individuals is called, and it's a familiar term I think for people, is bankruptcy. And bankruptcy can either be initiated by somebody you owe money to, one of your creditors, or it can be initiated, and often is initiated, by an individual themselves. Either way, the route into it is via what's called a bankruptcy petition. It's a short piece of paper, 3 or 4 pages long. It explains, on there you've got to put various bits of personal information on there, and name, address, that sort of stuff. And if you are a creditor petitioning for somebody else's bankruptcy, it will say what the debt is there. And if it's your own, you may well list your overall total liabilities to your different creditors, typically what we call your unsecured creditors. So in other words, that's not your mortgage company, that's credit cards, that's people who you owe money to generally, bank loans that are unsecured, catalogues, credit cards, all of that sort of debt that somebody can build up.
Just for clarity, what's the difference between a secured debt and an unsecured debt?
So a secured debt has got security, typically in the form of a mortgage or a charge on property. So your classic secured debt is your mortgage. Classic unsecured debt might be something like a loan you've taken out to buy a car or do some home improvements, but hasn't got a mortgage or a charge attached to it.
And what's the advantage to either starting a bankruptcy, let's take it one at a time, to starting a bankruptcy yourself? What's the purpose of it? Why would you do it?
I think that often what happens is when somebody gets themselves into a bad situation and a debt is really mounted up to the point at which actually no matter what they do, they're just never going to be able to clear it. And interest is compounding upon interest, and ultimately the individual a lot of the time in credit terms just can't ever sort of see a way of clearing this debt in any reasonable timescale. And I think that somebody, if they've got unsecured debt and it's going to take them more than, I don't know, something like 5 years to get that cleared or longer, I think it definitely does become an option for you. And in those circumstances, you take legal advice, you take advice from debt counselling, charities, CAB. Often they will say, look, in personal bankruptcy is an option. It does have consequences. You are declared bankrupt relatively quickly, typically a couple of months. I mean, ongoing theme on these podcasts is, unfortunately, delays in the civil courts at the moment. And whilst, I would have used to have said you'll be able to get an appointment in about 6 weeks, and that's stretching now certainly into 2 and 3 and 4 months, unfortunately. Once you are declared bankrupt, you do shortly after that have to have a meeting with somebody who will be appointed by the court on behalf of the official receiver, which is the government, who will be appointed as your trustee in bankruptcy, and their job is to oversee your bankruptcy, for want of a better word, or oversee the process. You will have to answer questions almost like a job application form type about what all of those debts are and what assets you might have, which could be perhaps sold to pay off some of those debts. He will then typically work out a sum of money that you are able to afford to pay back over a period of time. That sum of money is always something that is affordable. It's always something, it could be as low as sort of £50 or £100 a month or something along those lines, which won't really pay off much of the debt. But you don't need to worry about that, because once you're bankrupt, in effect, you are asked to make that contribution typically for a 12-month period. However, at the end of your bankruptcy, all of your debts are extinguished, and as if you are allowed to start again from fresh, and you don't owe any money to anybody at the end of your bankruptcy. Now, that doesn't mean there aren't consequences to bankruptcy, but the good thing, the positive thing about bankruptcy is at the end of that process, you have got a clean piece of paper. You own no unsecured debts to anyone.
So I guess it's got two positives, doesn't it? One is it clears the debt. It removes that obligation to repay. But in the shorter term, for those who are struggling, particularly if they're being put under pressure from creditors, it also stops the creditors from constantly, not harassing, but putting pressure on that person. Because, and it takes that level of pressure away from the individual, doesn't it?
They will stop writing to you once you are able to tell them that you've been declared bankrupt. They will. You should not have any contact from any of them, and indeed, actually, it would be unlawful for them to keep harassing you, the other side of a trustee in bankruptcy being appointed. And typically, if you are experiencing that, your trustee will write to them and say, you can have a claim in this bankruptcy, but you need to leave that individual alone. It can have some consequences, of course. Biggest one being in terms of your credit and credit rating. Once you are declared bankrupt, that's going to have a long effect on your ability to obtain credit on favourable terms. During your bankruptcy yourself, you're not actually allowed to have your own personal bank account. So there's some inconvenience there, and you've got somebody up to a point looking over your shoulder. But in my experience, most people who are worried about bankruptcy and bankruptcy as an option, virtually everyone I've ever met or who has done that has always said to me, the best thing I ever did in my life. Just allowed me to just completely put in a box that difficult period of my life financially, get it cleaned off and move on. There are some other complications because, of course, in certain professions, I think our own profession being one of them, you can't practice whilst you can't be a practicing certificate solicitor with a bankruptcy.
I think they've changed it, haven't they, for us recently in the last few years?
Right.
You can, but you have to be notified and you're not allowed to touch client accounts and the like and deal with money. But yeah, certainly there are professions.
MPs and different things like that. I think certain professions are...
accountants, financial regulatory types, anything that's got money where there's a temptation there. But yeah, so there's an implication.
So clearly,
there.
if you've got one of those type of jobs, you might need to look at some of the other options, which we'll come on to in a second. But I have to say, when you've got to the point where you just don't see financially any, you just aren't able to make any kind of dent in the level of the debts, getting some advice and putting forward, look, should I be thinking about bankruptcy, is worth doing. Again, most people who I know, and I know both personally and professionally, people who've done it, they've always, certainly a couple of years after it's occurred, said, I wish I'd done that years ago.
And of course, the other group that might not be able to do it, would have to think carefully, are directors, aren't they, of companies.
You can't be a serving director, yeah. And so, certainly if it's your own business, you're the 100% shareholder. That's going to cause you a problem for sure. But as I say, the process, there's a meeting or two with the trustee in bankruptcy, and up to a point, admin wise, that should, provided you cooperate, that should be it. If you have got property such as a house, the trustee in bankruptcy will in effect own your equity, and that will transfer over to the trustee in bankruptcy. So if you own property with my wife, when I was declared bankrupt, my share of the equity in the house, 50% of that equity, would actually then belong to the trustee. Often what we see is the trustee will be prepared to sell that interest in the property if the wife can raise some money, and not normally the full value, but can raise some money towards paying that off. Then you're not left in a situation where you will necessarily lose your house if you are declared bankrupt. And indeed, I would go so far as to say I probably rarely see that happen these days.
I think that's right. And in terms of what they can and can't do, I mean, so obviously you're going to sell assets. It's about the estate, if you like, your bankrupt estate, bankrupt estate being sold to pay off your creditors as much as you can.
Yeah.
But generally they won't touch certain things, will they? So they often won't take the roof from over their head, subject to what we just talked about.
They're not interested. Yeah, I mean, listen, they're not interested in televisions and video recorders. They might be interested in very expensive jewellery that you own, or Rolex watch or something like that. If you've got a Banksy painting holding, on the wall, they might be interested in something along those lines. But you're probably not going to have a Banksy painting holding on your wall. It would be painted onto the wall, I guess.
Possibly.
But if you've got, it's something that's high value and sort of readily sellable, they might be interested in trying to get a return for because that's their job really, to get a return for the creditors. They won't be paying the creditors every penny in the pound that is owed to them, but to make something, to cover their own costs and to make something of a return.
Equally, they're not going to go for things like tools of the trade generally.
No. So if you've got, you're a mechanic and you've got a snap-on toolbox full of tools, they're not typically going to be interested in that. Or a butcher's. Butcher's been my sort of analogy on this podcast recently. But if a butcher's got a sort of set of knives that are the tools of their trade, they're not going to be taking those off them.
Which makes sense, because to a degree you want that person to still work so they can put money back into the bankrupt estate.
They're typically they're only really, in terms of personal property, looking at something that you have got that is very readily sellable and of high value. If you've got something like that, then that a trustee would be interested in taking that off you and selling it for the benefit of the creditors. But it would have to be, as I say, the days of them going after televisions and even cars, to be quite frank, which people will need to get to work. They typically do not try and make somebody sell their car. Again, if it was a Ferrari,
it'd be a different story.
It would be a different story. But for most people's day-to-day vehicle that they use for their commute, they're not going to be interested in taking that off their hands.
We've talked about bankruptcy from an individual perspective, and we'll come back to what you might do as an individual in a moment again. But it's probably a good point, because you've already mentioned that there are two routes into the bankruptcy. One is you put yourself there, and the other is that somebody else can put you there. If you are owed money, why might you think about putting somebody into bankruptcy?
Well, in effect, even though officially it's not meant to be used as a debt collection tactic, it's a debt collection tactic. Now, you don't really want to get that person declared bankrupt unless they're somebody who is literally causing you ongoing financial harm by being a non-bankrupt person, But for them, I'm trying to think of somebody like a gambling addict who was continually sort of spending families' monies or something along those lines, or almost like a financial safeguarding issue. But if you are a creditor and somebody owes you money, somebody in business or something along those lines, you don't really want them to declare themselves, but you don't want to make them bankrupt, because if they go bankrupt, the chances of you getting much of a return on your money is probably relatively low. But because people generally, notwithstanding what I said, do not want to be made bankrupt, the threat of a petition, either by you writing to them or you serving on them something that's known as a statutory demand, which is in effect a 21-day notice that unless you pay this debt, you're going to petition for their bankruptcy. They can often be quite effective tools of forcing the hand and forcing them to pay you, maybe lending some money off a relative, or getting somebody to pay a debt that's fallen due. Now, strictly, and this applies come on to corporate insolvencies, the law does say, the case law says that you're not meant to use insolvency as a debt collection tactic. That it's a collective remedy, and that's. And that it isn't a debt collection.
Yeah, I think the reference is something like not to be used as a blunt instrument of debt collection, isn't it? Is the quote from the
and you'll find certainly if you take advice from ourselves, we would only advocate it if the debt that was due and owing was clear evidence of the person just couldn't, can't pay or won't pay, right? That if there's any kind of dispute in relation to the debt, we would steer a long way clear of using insolvency as a methodology of trying to collect that debt in.
You do see this quite frequently, and probably more frequently than we'd like, is where people do come and say, oh, I want to make that person bankrupt, and they want to use it as a debt collection tool. But that has its own difficulties, doesn't it?
Yeah. I mean, let's just be clear. If you succeed in your aim of making that person bankrupt, if you get 5p for every pound that they owe you, you've probably done quite well.
Yeah, and if you're doing it, who's paying the costs of it?
Well, if you're petitioning somebody else's bankruptcy, the petition fee, is yours to bear.
And when you do that in the court, you're not only paying the court fee, you're also putting a deposit down on the insolvency practitioner's fees, don't you? Generally?
Yeah, you are generally doing that, and there's a proper. You will typically need a lawyer or some paid professional to go through that process. For you've got to file evidence that you've served the proceedings, you've served the paperwork. You've got to, there's all sorts of certificates and all of the insolvency processes that you've got to. It's an expensive game. I'm not saying that you shouldn't use it. It definitely is a tool in the armoury. However, at the same time, I think that it's to be used sparingly and only in sort of certain circumstances, really. And
there's risks, isn't there? But whereas where you can sue somebody, you might get the figure wrong in your pleadings because instead of owing you $5,000, they owed you $4,500. Probably. But if you get it wrong in an insolvency proceedings, that's really risky, isn't it? So, for example, if we're suing somebody because we've got to bring a claim to get a judgment debt, and we put in, let's say, £6,000 on the claim form, but it turns out that they're owed $5,500, it's not the end of the world because you'll recover something, and the court has its discretion to just substitute in the value and make a judgment for what you're owed. You can't do that, can you, with a stat demand or an insolvency? Yeah,
because if you get the number has to be spot on right as an undisputed debt, because if you've got it wrong, I mean, that's a judge will often use that as a reason for chucking out the demand or setting aside the statutory demand. Listen, I mean, if you get one of these documents, and whether you want to avoid being declared bankrupt, or you think there's a dispute, you do need to quickly. It's not the sort of paperwork that you can ignore. Certainly, there's any letter that threatens bankruptcy or any the formal statutory demand document, which will say statutory demand on it, you do very quickly, within days, need to be speaking to a lawyer to get that sorted out for you. Make sure that either the debt is paid, or that if there is a valid dispute, that dispute is put forward. Typically, in those circumstances, if the creditor is well advised, they will withdraw their demand. If they won't, you can apply to court to have the demand set aside, and if it's got as far as the petition, you can get an order from the court to throw out the bankruptcy petition.
And that's expensive if you get it wrong, isn't it?
It's expensive, and also, I mean, I've seen a couple of times this year people get themselves into a mess and get declared bankrupt, even though they've got lots of assets. But there was from a tax bill to a large creditor that was owed a lot of money, and even though their family was reasonably wealthy, or there were certain things that could be done to avoid that situation, they got declared bankrupt. Once you've been declared bankrupt, you can apply for what's known as an annulment. But that, again, is an expensive process, because to get an annulment, you have to then pay every single one of your unsecured creditors off. There's a process that you have to go through with the official receiver, and if anyone's appointed as a trustee in bankruptcy, with them. And there's typically a court hearing to get the annulment through. It wouldn't be outside the realms of possibility that just in terms of professional costs alone, it might cost you somewhere in the region of £5,000 to £10,000 to get that annulment through. And
in the meantime, your credit's affected, so the credit you might have had open to you is probably not going to be there.
It's only going to be really if you can speak to a friend or a relative who's prepared to lend you some of the money. I mean, your bank account typically will be frozen in those circumstances. Well, typically will be frozen in those circumstances. So that's not going to be an avenue if you've got the money in a savings account to sort of clear these debts. Absent with the cooperation of the trustee, again, it gets expensive. Getting that money out to get the creditors paid is going to be tricky on an annulment anyway.
And just to sort of finish off this area, if you've got a case that's been run, be it you're running it against somebody else, or if you've got a case being run against you, what happens if a bankruptcy order's made whilst that's going on?
Well, it will ultimately, in effect, impose a stay of proceedings on those court proceedings. It will stop. It'll press the pause button on the proceedings, and then the combination of if you're pursuing that claim, your lawyers can, in certain circumstances, apply to have the stay of proceedings, the pause button set aside. However, typically the court will only. It's probably rare and few and far between when a court will allow that to do that, because it is in many cases a pointless exercise, because in terms of you getting any money there, the court will want to. If you're just going to be dealt with as an unsecured creditor in the bankruptcy, the court will say, well, there's no point in us setting. If what you're seeking is a money judgment, there's no point in us allowing this stay to be moved. The press play on that video recorder so the proceedings can go ahead, because there's no financial return. It's slightly different when what you're seeking is a non-monetary claim. If you'd got an injunction for the return of some property or actually possession type processes to get a house or some land, to recover some land, in those circumstances, more likely that a court is going to allow you to have that stay of proceedings lifted.
But even then, it's going to put it down initially. So if you've got a hearing that's coming up and you've got that going on, you've got the chance to argue, but most courts will usually give the trustee in bankruptcy a chance to get in, get their feet under the table and get sorted.
And work out how they're going to deal with it. You know, and we've had that happen, several times even in the last 12 months, right?
Yeah. Absolutely.
It's one of the risks always of pursuing claims against people. And before you ever start claim against someone is, are they, in the likelihood that the proceedings run, are they going to be able to afford to keep running the case themselves? Because if they get declared bankrupt, chances are that that's the end of the process, and your claim will be dealt with as a claim in the bankruptcy as opposed to you getting a judgment. And
it's certainly a tactic that's sometimes used. I know I've seen it, where people say, oh, if you issue this claim, we're going to go bankrupt. And then you have to make a commercial decision, don't you?
And sometimes they're calling you bluff, and sometimes people do call their bluff. Happens several times each year, I would say, in my practice, that you face that situation.
In terms of the individuals, then, we've talked about bankruptcy. What else can they do? What other option is there that they might be able to explore rather than being adjudged bankrupt?
So the main one, I mean, first of all, and perhaps informally, you may just be able to do deals with your creditors. Again, we've got some good people who can help you at Citizens Advice. There are some charities out there who will help you try and negotiate with your creditors, whereby I've seen where a credit card company will accept. Tell you what, if you pay us 50% of the £30,000 debt, and you can pay that in one lump sum, we'll forgive the rest, we'll write the rest off, or perhaps if we'll cap the figure at a certain level and we'll allow you to pay by instalments. Mm-hmm. Lots of those deals are often there. I mean, the issue sometimes with doing that on your own, when you're in debt crisis, your mental health can be affected. It's a terrible time in someone's life, and to do the informal type arrangements, it's quite a lot of administrative work for an individual to do, and that's why, again, if you are going to do that, it's not work that we actually as solicitors ourselves, we're not regulated to do that sort of work, but there are organisations out there and charitable organisations that can help you try and see if you can cut deals with a large number or even a small number of unsecured creditors. And I mean, that's, I don't know what I particularly call that. Sometimes somebody might call that a workout, or just, doing deals with those unsecured creditors. And that often is what people will do, probably do that more often than not. However, if that isn't going to work, perhaps there's just too many of them, but bankruptcy is not an option for you because you're worried about you're a director of the company and you're worried that you lose your directorship, or you're in a profession that precludes you from practicing, then often what will happen is people will do what's called an IVA, which is an Individual Voluntary Arrangement. And you will typically go and see an insolvency practitioner, and they would be if they're appointed, they become the supervisor of the arrangement, and that they put a deal which, if 60% of the unsecured creditors accept, will be binding on all of them. Mm-hmm. And that deal typically will either be some kind of arrangement whereby you're selling some property. So the IVA presses pause on everything, you'll sell the property, and then when the property is sold, they'll get paid X in the pound. It's whatever deal that supervisor can do with your creditors. Maybe it's 50% of the equity that's due to you would be then shared between the creditors. Or alternatively, sometimes it's some kind of instalment plan. Mm-hmm. Sometimes it's a combination of the both. Typically, for that to be attractive, your creditors get to vote on that. Typically, for an IVA to be attractive, it's got to be returning, an improvement than what they would get if you were declared bankrupt. Mm-hmm. And we see these. We see some creditors adopt a tougher line than others when it comes to approving or disapproving the IVA. I mean, I think there's got to be an attractiveness to them. I think there is sometimes a bit of a bad name for IVAs, and sometimes I've been a little bit disappointed whereby the actual terms are quite tough. There is the level of instalment that you have to pay every month is too high to be affordable to the individual. And perhaps for a while, by robbing Peter to pay Paul, they can afford to pay it, but then something goes wrong and then they have to go bankrupt anyway. Mm-hmm. And I always feel a little bit frustrated for those individuals, because they would have just have been better to have gone bankrupt in the first place, and that everything their debts would have been long since washed clean. Mm-hmm. Whereas sometimes those IVAs, if they fail after 4 or 5 years, it's a real heartache for the individual concerned, because their debt problems could have been long in the rearview mirror if they've gone down an alternative plan. I think that if you are going to explore that, it's really important. Again, I think people like the Citizens Advice should be your first port of call to perhaps recommend insolvency practitioners. You want a proper qualified insolvency practitioner, regulated typically by the accountants. You tell me what is it? Royal Association of they've got a couple of regulatory bodies, haven't they? Accountants.
You've got the ICAW, isn't it? The chartered, and then
we should know the answers to this, but we don't. But the point is, what you don't just want is some sort of advert that comes up on your Facebook feed because it is an area where unfortunately there are a lot of cowboys out there.
Yeah.
We could always, again, for people who are within our network, for our clients who are facing these difficulties, we would refer you to people that we know and trust, who can assist you and give you an honest appraisal whether an IVA, as opposed to bankruptcy, or as opposed to just speaking to some of your creditors, is the way for you. All of those free options should typically be on the table, and a good person specialising in this area will try and suggest the process that is better for you, as opposed to the one that makes them the most money. And most of certainly the regulated accountants and insolvency practitioners that we would deal with will always give best advice in those circumstances.